Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to start the concept of resolution plan considerations by judiciary. In the previous classes also we have discussed about the resolution plan. It's a continuation topic. So in the previous class we have discussed the mandatory contents of resolution plan, what should be there in the resolution plan we have discussed. Then we have discussed what is insolvency resolution cost, what is the meaning of insolvency resolution cost, and the meaning that is given under section 5 of the act we have discussed. Then payment to operational creditor, when you are making the payment, so minimum value must be there and payment in priority must be there. We have discussed this concept. Then we discussed about dissenting financial creditors. So when you are proposing the plan before the COC, and when the COC is approving, possibility is there dissenting financial creditors may be there. So the dissenting financial creditors are having right to receive the payment in priority. We have discussed this point. Then contents relating to avoidance of transactions in resolution plan we have discussed. Then treatment of provident fund, how you are going to treat the provident fund in resolution plan. Then resolution plan, at the last we have discussed that resolution plan cannot contravene the other legislations. So voting on resolution plan we have discussed briefly. So these are all the various points that we have discussed in the previous class. In continuation of that, today we are going to discuss once the resolution plan is approved. Okay, so in the last class we have discussed up to the approval of the resolution plan. So once the resolution plan is approved, okay, then how you are going to file with the NCLT, then how you are going to treat with the how NCLT is going to treat with the resolution plan. Okay, so these are all the various things that we are going to discuss in this class. So before that, okay, so let us look at the form number H. Okay, so whenever you are filing resolution plan with the NCLT, the resolution professional is expected to file resolution plan in form number H. Now let us look at form number H. This is form number H. In form number H, you are going to give the compliance certificate. So form number H actually has to be attached along with the resolution plan. Okay, so resolution plan is one document and form number H is another document. Okay, so along with the form number H, you are supposed to make an application before the NCLT. Okay, so form number H, so it is nothing but compliance certificate issued by the resolution professional. So here he is going to give the details as to details of CRP, name of the CD, date of initiation of CRP, date of appointment of CRP, IRP, date of publication of public announcement. So as already we have discussed various timelines in the previous sessions. Okay, so everything will be there here. Okay, then I have examined the resolution plan received from so and so resolution applicant. So he is going to write the name. Then I hereby certify that the resolution plan complies with all the provisions of IBC and the rules made thereunder. Okay, so then list of financial creditors, name of the creditor, voting share, how they have voted in favor or against the resolution. Then amounts provided for the stakeholders under the resolution plan, how you are going to provide the amounts. Okay, total amount claimed, total amount admitted, and amount provided under the plan. You are supposed to give the amount as well as percentage. Okay, so like this you are supposed to give all the details. Then interest of existing shareholders have been altered. Okay, how they are going to be altered. Then compliance with resolution plan is as under. So various sections are there. So whether did you comply with the various sections or not, you are going to give the declaration. So these are all the various sections already we have discussed. Then timeline, in the previous lessons we have discussed the timeline. So actual timeline under regulation 40A, then actual time. Okay, so did you comply with the law or not? From this we can understand. Okay, then time frame proposed for obtaining the relevant approval. So as already we have discussed, the resolution plan must have the approval details also. If the resolution plan requires any approval from any other authority, then within what time you are supposed to get the approval and how much time you are going to take. Okay, so everything must be given. Okay, if any contingencies are there, so then please give the details. Then non-compliances, if any non-compliances are there, then please give the details as to non-compliances also. Then provide the details of section 66 or avoidance of application file which is pending. Okay, signature. Okay, so this is how you are going to give the compliance certificate along with this compliance certificate must be filed along with the resolution plan. So whenever you are filing an application with the NCLT, that is resolution plan with NCLT, you are supposed to give form number H, from compliance certificate. Then section 30 subsection 6 provides that the resolution professional shall submit the resolution plan as approved by the committee of the creditors to the adjudicating authority. So subsection 6 provides that once the approval is done or once the approval is given by the COC, then resolution professional is expected to submit the resolution plan to the adjudicating authority. In the case of Appu Hotels case law, NCLT held that the resolution plan modified after the approval of COC but before submission of NCLT, okay, so it amounts to material irregularity. So please remember, once it is approved by the COC, okay, so you are supposed to submit to the NCLT. So after submitting to the NCLT, there is no possibility of modification. Okay, so you cannot modify. Okay, so before submission to the NCLT, suppose approval is done and you are going to submit resolution plan with the NCLT. Within this time period, if you are doing any modifications, then that modification amounts to material irregularity. Okay, so it cannot be accepted. In another case law, Dinesh Gupta versus Vikram Bajaj, liquidator of Best Foods Limited, NCLT held that any alteration to the resolution plan post the approval by the COC will have to undergo another round of voting. Okay, so once if the resolution plan is approved by the COC, immediately with that approval only you are supposed to submit to the NCLT. If whenever there is a change is there, you are supposed to undergo the voting process once again. Okay. So in another case law, Epic Singapore case law, the Supreme Court held that COC cannot request for any modification of resolution plan. Okay. Then one more condition is that, can I modify? Okay, so can I request the NCLT to modify after submitting the plan to the NCLT? Can I request modification? No, even that is also not possible. Okay, so COC cannot request any for any modification of resolution plan once the same has been duly approved and presented before the NCLT. So the only possibility is that once it is approved, before submitting to the NCLT, possibility is there, again you can modify, again you can conduct the voting. So modification must always be done through the voting only. Okay, so without voting, if you are doing modification, then that amounts material irregularity. Okay, then once it is submitted before the NCLT, then NCLT is going to give the approval, so which is provided under section 31. If the adjudicating authority is satisfied that the resolution plan as approved by the COC under section 30 meets the requirement as referred in section 30 clause 2 subsection 2, then it shall by order approve the resolution plan. So he is supposed to verify whether the conditions specified under section 30 subsection 2 is it satisfied or not. So once the conditions are satisfied, he shall approve the resolution plan. Okay, then it shall by order approve the resolution plan, which shall be binding on corporate debtor. Okay, once the resolution plan is approved, it is binding on corporate debtor, its employees, members, creditors, including the central government and state government or any other authority. So that's why in the previous classes we have discussed that. Okay, so when we are talking about the resolution plan, we have discussed that once the resolution plan is approved, it is a rem. It will act in rem. So that means against everyone. So everyone is binding. Okay, so everyone is bound by this resolution plan, maybe central government, state government, local authority, members, employees, everyone. Okay, then which further provides that any local authority to whom a debt in respect of payment of dues arising under any law for the time being in enforcement, such as authorities to whom statutory dues are owed, guarantors or other stakeholders. Okay, so it is binding on everyone. Then section further provides that the adjudicating authority, before passing an order for approval of resolution plan, he should satisfy that the resolution plan has the provisions for its effective implementation. So as already we have discussed in the previous classes, one of the mandatory requirement is that how you are going to implement, how you are going to manage the resolution plan. So there should be some agency for managing the resolution plan. Okay, so whether these contents are there in the resolution plan or not, the NCLT is supposed to verify. That is adjudicating authority, they are supposed to verify. Okay, then once it is done, they are going to give the approval. So in the case of K. Shashidhar versus India Overseas Bank. Supreme Court held that the adjudicating authority cannot examine the matters beyond the tenets of Section 31, subsection 1. Okay. So the scope of NCLT in this case is very limited. Okay. He has to verify only Section 31, subsection 1. Okay. So unilateral legislative guide also provides that the law not require or nor permit the court to review the economic and commercial basis. So what is expected from the NCLT? Whether did they follow the procedure or not. NCLT or adjudicating authority cannot verify, cannot review the economic and commercial basis of decision. Okay, so please remember the IBC is purely based on commercial wisdom of the COC. So they are supposed to take the decision. Okay, so that's why unilateral model law also provided that, legislative guide also provided that the law should not require or permit the court to review the economic and commercial basis of the decision. Okay, not that it be asked to review particular aspect of the plan in terms of their economic feasibility. So NCLT or any other court. Okay, so because unilateral is a model law, so any court of law under insolvency regime, they cannot ask the economic feasibility of the plan. That is how the resolution plan must be approved. Okay, they cannot go beyond the tenets of the legislation. So if you observe regulation 35, which provides that the resolution plan shall give fair value as well as liquidation value. So in the case of Maharashtra seamless case law, the Supreme Court observed that the resolution plan whose value is below the liquidation value can also be approved. Okay, so when you are preparing the resolution plan, so you are supposed to give the fair value as well as liquidation value. Even the professional is appointing the valuer, he is going to give the fair value as well as liquidation value. So possibility is there, the COC may approve a plan which is below the liquidation value, but you cannot question. Okay, the resolution plan whose value is below the liquidation value can also be approved by the COC because it's a commercial wisdom. Okay, so the COC is going to take the decision. Okay, then resolution plan which does not conform with the requirements of Section 31(1) may be rejected. So please remember, Section 31(1) is mandatory. Okay, if it is not conforming Section 31(1), then it can be rejected. Okay, so when the resolution plan is rejected, what will happen? The CD is either put into liquidation. Okay, we are going to discuss in the subsequent lessons how liquidation will happen, or fresh expression of interest for initiation of prospectus resolution plan can be initiated. That means again the process will start. Okay, so either you can start the process once again, or else you may go for liquidation, but majority of the cases they'll give the order for liquidation only. Okay, then in the case of EBIC Singapore case law, the Supreme Court observed that the resolution plan shall take over CD whatever there is basis. So when you are preparing the resolution plan, okay, so the resolution plan shall take over the CD whatever there is. Okay, so whatever as it is they are supposed to take. Okay, so in another case law, so Panchatattva case law, the Supreme Court held that conditional resolution plan cannot be approved. So these are all the various things that has to be considered by the court. Okay, whenever they are approving. Okay, so whether NCLT can approve the conditional resolution plan? No, NCLT cannot approve the conditional resolution plan. Okay, then in another case law, Dr. C. Bharat Chandran versus Sabine Hospital and Research Center. So in this case law, NCLT Chennai bench held that NCLT, that is adjudicating authority, cannot go into the question of justness in rejecting the resolution plan. He is supposed to verify whether did they follow the procedure under the law or not. Okay, and whether is it approved by the COC or not. So he is not here, or he cannot verify justness of the plan. Okay, because that is up to the COC. The law has given autonomy to the COC to approve the resolution plan. So that's why in various Supreme Court judgments also it was held that commercial wisdom is a paramount. It is very essential factor. Okay, you cannot question the commercial wisdom of the COC. In another case law, Rajesh Kumar versus Rabindra Kumar Mintri, the NCLT held that they approved the resolution plan by COC leads to presumption of its feasibility and viability. So it was held that once COC approves the resolution plan, because in the COC they are the business people, they know how to do the business. Okay, once it is approved, then the NCLT will presume that the plan is feasible and viable. Okay. Then consequences of approval. So in the previous slides we have discussed the various factors to be considered while approving. Once it is approved, what will happen? Section 31 subsection 3 provides that after the order of approval under subsection 1 is given, then, so as already we have discussed, from the initiation of CRP, moratorium will be effective. So once the approval resolution plan is approved, the moratorium order passed by the adjudicating authority under section 14. In the previous classes, we have discussed in detail about the moratorium. Okay. So once the moratorium is ordered, okay, so this will, the moratorium will be effective from the initiation of CRP till the approval of resolution plan. So once the resolution plan is approved, okay, the moratorium shall cease to have the effect. Okay. Then subsequently, the resolution professional, he shall forward all the records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the board to be recorded on its database. Okay, you are supposed to forward it to the board. Okay, here board means IBBA. So to the IBBA, you are supposed to forward the data. Then, once the resolution plan is approved, the doctrine of clean slate will be applicable. So what is this doctrine of clean slate? Doctrine of clean slate, the concept is that once the resolution plan is approved, the company will be taken over by another management. Okay. So whatever may be the activity, whatever may be the liability which is there on the company, now such liability will not be there. Okay. Such liability cease to exist. So does it mean that the persons are also not liable? Officer in default? No. Officer in default, such person, so their liability cannot be excluded. Okay, but company will not be liable subsequently for the previous activities. Okay, so there is a concept of clean slate. Okay, we are cleaning everything and we are giving it to the other person. Okay, whoever is submitting the resolution plan to the other person, we are cleaning the company and we are giving the company to other person. Okay, that is the basic concept of doctrine of clean slate. Then what is the liability for prior offenses? Okay, so if any prior offenses are there, so to what extent the liability? Section 32A provides for liability. Okay, so which provides that notwithstanding anything contained to the contrary contained in this code or any other law for the time being in enforcement, the liability of the corporator for an offense committed prior to the commencement of CRP process shall cease. So before CRP process, whatever may be the liability, so all this liability shall cease to exist. Please remember. The corporator shall not be prosecuted for such an offense from the date of resolution plan has been approved by the adjudicating authority. Why? Because all these claims, all these liabilities will be taken care by the resolution plan. So by taking everything into consideration, the resolution plan will be prepared. So that's why once the resolution plan is prepared, okay, all the liabilities prior to the CRP will cease to exist. Okay, the adjudicating authority under section 31, if the resolution plan results in the change in the management or control of the management, control of the corporator to a person who was not, okay, a promoter or in the management or control of the corporator or related party of such person, then person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offense, or has submitted or filed a report or a complaint to the relevant statutory authority or the court. So who will not be excluded? Any person, individual, they are not excluded from the liability. Okay, so only company is excluded from the liability, provided that if a prosecution had been instituted during the CRP process against such corporator, it shall stand discharged from the date of approval. So if any prosecution is started during the CRP process, then automatically all the charges will be discharged. Okay, so from the date of approval of resolution plan, subject to other requirements. Okay, so in the case of Ajay Kumar Bishnoi versus TAP Engineering, so in this case, Madras High Court held that the liability of the CD is extinguished. Okay, when we are applying the clean slate theory, it is only to the corporator. Please remember. Okay, the liability of the CD is extinguished in proceedings, but the liability of the officers in default shall continue. Okay, because guilty mind is there. Okay, they are the people who are in charge, who were responsible. So that's why the liability of the officers in charge shall continue. Okay, but you are only clearing the CD. Okay, this point you are supposed to remember. Then approval from the other authorities. So section 31 subsection 4 of IBC provides that the resolution applicant shall, pursuant to the resolution plan approved under subsection 1, once it is approved by the adjudicating authority, obtain the necessary approval required under any law for the time being enforcement within 1 year. So within 1 year, if any approvals are required, okay, so maybe the company is regulated by other regulatory authorities, okay, so some other legislations may be applicable, okay. In such cases, within 1 year from the date of approval of the resolution plan, he is expected to get the approval, okay, the resolution applicant, okay. Then provided that the resolution plan contains a provision of for combination. Okay, so in case of combination, which is referred under section 5 of the Competition Act, okay, so in other cases, okay, once the resolution plan is approved, subsequently within 1 year you are supposed to get the approval. But whereas in case of combination, okay, please remember you are supposed to obtain the approval from the COC prior to the approval of such resolution plan. Okay, so before getting the approval from the COC, forget about approval by the NCLT. Okay, so before getting approval from the COC only, first you have to submit your plan to the COC. Okay, as per the provisions of the Competition Act. Okay, so once that is submitted, okay, once if you receive approval from the CCA, Competition Commission of India, then only you can place the resolution plan for the approval or for voting before the COC. So that means in case of Competition Act, okay, the approval shall be obtained not from the date of approval of the resolution plan by the NCLT, but it should be before approval by the COC itself. Okay, so that this point you have to remember clearly. Okay, then let us discuss other provisions. Okay, section 31, other provisions relating to approval. Okay, so once approval is done, what are all the other consequences? Okay, section 31 provides that NCLT do not have power to modify the plan. Okay, so whether NCLT is having any power to modify, so please remember, as per the section, NCLT is having power to either accept, that is approve, or reject. That's it. They don't have any other power. Okay, so regulation 39(5) provides that the resolution professional shall forthwith send a copy of the order of the adjudicating authority approving or rejecting a resolution plan to the participants and the resolution applicant. So once if you receive the approval from the NCLT, it is the responsibility of the resolution professional to send a copy of the order to the COC and other stakeholders. Then regulation 39(5)(a) provides that the resolution professional shall within 15 days, okay, so within 15 days he shall, okay, once the approval is done, within 15 days he shall intimate to each claimant, okay, whoever has submitted the claims. Okay, so we have discussed in the previous lessons how to submit the claims, okay, by the operational creditor, financial creditor, other than the operational creditor, workmen. So we have seen the forms also. Okay, so whoever is having the claim, to each and every person he is supposed to intimate about the order. Then regulation 39 subregulation 7 provides that no proceeding shall be initiated against the IRP or the resolution professional, as a case may be, for any action of the corporator prior to the insolvency commencement date. Okay, so which is giving a protection to the resolution professional. Okay, so when if any activity is done during the CRP, then resolution professional is responsible. But if any activity is done before CRP process, then resolution professional shall not be responsible. Okay, because it is done by the previous management. Okay, so that's why this regulation provides that, okay, you cannot take any action, you cannot initiate any action against the interim resolution professional for any action of the corporator before commencement of insolvency date. Okay, then regulation 39(8) provides that a person in charge of the management or having control of the business and the operations of the corporator after the resolution plan is approved, he shall make an application to the adjudicating authority for seeking assistance from the local district administration. Okay, so once if you get the order from the NCLT, okay, so you have to implement it. For implementing, sometimes you may require you may require assistance from the local authorities also. For seeking assistance from the local authority, okay, you are supposed to approach again NCLT. NCLT will give the appropriate orders to the local authority. Then local authority, local administration will cooperate with you. In the case of GP Global Energy Private Limited versus Sandeep Mahajan, monitoring professional for Allied Strip Limited, NCLT observed that NCLT has jurisdiction to extend the time for implementation of resolution plan in the interest of justice. So when you are submitting the resolution plan, you are going to give the time framework. Okay, and it is going to be approved by the COC. Then COC will submit or will make an application to NCLT. NCLT will approve the resolution plan. So generally resolution plan will have the time framework. So whether can we extend the time framework? Yes. In the interest of the justice, NCLT is having power to extend the time limitation for implementation. Okay. Okay. So we are not talking about the time framework under the IBC. Subsequent to once it is approved. Okay. So once the resolution plan is approved, whether NCLT is having power to extend the time limitation for implementation? Yes. They are having power to extend the time limitation. Then what are all the other obligations? So once the resolution plan is approved by the NCLT, okay, then resolution professional is having responsibility to preserve the documents. Okay, so these are all the various documents to be preserved by the resolution professional. So he is supposed to maintain the documents relating to his appointment as interim resolution professional or resolution professional, documents relating to his appointment and handing over takeover of the assignment, and his appointment as interim resolution professional, including the terms of appointment, okay, admission of CD into corporate insolvency resolution process when it was admitted, documents relating to that. Then when he made the public announcement, documents relating to public announcement, okay, the constitution of committee of the creditors and its meetings, okay, so minutes copy, etc., etc. Then claims, verification of claims, list of creditors. He must be receiving the claims. He must be verifying the claims. He must have done the, he must have prepared the list of creditors. So all these things must be maintained. Okay, he's supposed to maintain the registers. Then engagement of professional. As already we have discussed, once the resolution professional is appointed, he can appoint other professionals, including the register valuers. Okay, so he is expected to appoint minimum 2 register valuers. Then the orders, the letters relating to appointment, letters relating to that, and the insolvency professional entity, including the work done, report, etc., submitted by them. So everything must be maintained. Okay, so all the documents he is supposed to maintain. Okay, information memorandum, then all filings with the adjudicating authority, whatever he filed with the adjudicating authority, then invitation, consideration and approval of the resolution plan, statutory filings with the board, okay, with the insolvency professional agencies. So subsequently we are going to discuss in the subsequent lessons about the insolvency professional agencies. Okay, so you are supposed to file certain statutory filings with the board as well as insolvency professional agencies. So all these filings must be maintained. Okay, then correspondence during the CRP process, insolvency resolution process cost, how much incurred, the bills relating to that, everything he is supposed to maintain. Okay, then appeal against the approval of resolution plan. Okay, so once the resolution plan is approved, can you go for an appeal? Okay, so is there any possibility? Yes, there is a possibility is there, but only limited scope for the review. Okay, so under section 32 of the IBC, which provides that when you can go for an appeal, you are supposed to go for an appeal when the conditions specified under section 61 subsection 3 are satisfied. Now let us look at the conditions. Okay, under section 61 subsection 3. When you can go for an appeal, the approved resolution plan is in contravention of provision of any law. Okay, if the resolution plan is in contravention of any provision of the law, then you can go for an appeal. Then there has been material irregularity in exercise of powers by the resolution professional. So material irregularity is there during the CRP process. Then debts owed to operational creditors of the CD have not been provided for in the resolution plan. Okay, so as already we have discussed, in the resolution plan, you are supposed to give priority to the corporate operational debtor, how you are going to make the payment. Okay, so they have not given priority. Okay, they have not provided actually. Then the insolvency resolution process costs have not been provided for repayment. Okay, in priority to all other debts. So whenever you are preparing the resolution plan, one of the important component is that you are supposed to pay insolvency resolution process cost, as already we have discussed previously, first you should pay that. Okay, so that is not provided in the resolution plan. Okay, then resolution plan does not comply with any other criteria as may be specified by the board. So if these conditions, okay, these 5 conditions are satisfied, then you can go for an appeal against the order given by the NCLT. Let us recap what we have discussed today. So we have discussed about filing of resolution plan, how to file resolution plan we have discussed. Then we have discussed about approval of resolution plan by the NCLT. So how NCLT is going to approve the resolution plan we have discussed. Then we have discussed about the resolution plan of CD shall be taken over where whatever there is. Okay, so as it is you are supposed to take over. Okay, so there is no concept of changes. Okay, then consequences of approval. Okay, once the plan is approved, what is the consequences? Okay, moratorium will be suspended. Okay, doctrine of clean slate will be applied. Okay, then liability for prior offenses, how the officers or corporator is liable to the prior offenses we have discussed. Okay, then approval from the statutory authorities, how to get the approval from the statutory authorities. Generally, once the approval is done, plan is approved, subsequent to that, within 1 year you are supposed to get the approval from the statutory authority. But one exception is that in case of Competition Act, you have to get the approval in advance. Okay, then power of NCLT to modify the resolution plan, whether NCLT is having any power to modify the resolution plan. Then immunity to resolution professional. Then we have discussed about obligations of resolution professional to preserve the record. So these are all the various concepts that we have discussed in this lesson. Thank you.